If you're retired, you travel between states, or you've relocated somewhere new after decades of working, a Supreme Court ruling from this past June changes something you may have been quietly working around for years without ever realizing there was a better legal answer coming. On June 25, 2026, the Supreme Court struck down a Hawaii law in a case called Wolford versus Lopez that had required concealed carry permit holders to get explicit permission from a business before carrying a firearm inside, and the ruling's reasoning directly threatens nearly identical laws in California, Maryland, New York, and New Jersey. If you're a retiree who splits time between two states, someone who moved to a new state after retirement and is still learning its gun laws, or simply someone in your 60s, 70s, or beyond who has carried a firearm responsibly for decades and just wants a straight answer about where you actually stand right now, this ruling matters to you directly. Retirees face a genuinely unique version of this confusion compared to younger permit holders, because seasonal relocation, extended travel, and settling into an entirely new state's legal landscape after decades in one place are simply far more common in retirement than during a typical working career, meaning the practical stakes of getting these state-by-state details right are often higher for exactly this group of carriers. I'm going to walk you through exactly what changed, why retirees and people who travel or relocate face a uniquely confusing version of this legal landscape, and what you need to actually do differently starting today. Before we get into it, if you want breakdowns that translate a Supreme Court ruling into what it actually means for your specific daily life, not just legal theory, subscribe and turn on notifications right now. This is exactly the kind of ruling that matters enormously in practice for people who carry regularly and move around, whether that's seasonally between a summer home and a winter home, or permanently after choosing a new state to retire in. And getting the practical details right matters more than getting the legal theory right. Let's get into what actually changed and what you need to know. Here is the core of what happened, in plain terms, before we get into the state-by-state detail. Hawaii had a law requiring concealed carry permit holders to get affirmative, explicit permission from a business owner before bringing a firearm onto private property open to the public, everything from a grocery store to a pharmacy to a restaurant. Before this ruling, the default assumption in Hawaii and in several other states with similar laws was that carrying into an ordinary business was illegal unless that specific business had posted a sign welcoming firearms, something the overwhelming majority of businesses simply never do. 3 Maui County residents holding concealed carry permits, along with a firearms advocacy organization, challenged this law back in 2023, and the case worked its way up through the federal court system over the following 3 years before finally reaching the Supreme Court. The Supreme Court found this reversed the traditional legal default that governs entry onto private property generally, and struck the law down as unconstitutional. The practical result: permit holders in Hawaii, and very likely soon in California, Maryland, New York, and New Jersey, can now generally assume they're allowed to carry into an ordinary business unless that business has specifically posted a sign saying otherwise, the same default rule that's long applied in most of the rest of the country. The first segment of what this means for you specifically involves seasonal travel between states, because this is one of the most common and most legally confusing situations retirees actually face. If you're what's sometimes called a snowbird, spending summers in one state and winters in another, you've likely already run into the reality that gun laws don't just vary from state to state in terms of permit reciprocity, they can vary dramatically in terms of where you're actually allowed to carry once you're legally in a state with your permit recognized. Before this ruling, if your winter state was Hawaii, or if it's currently California, Maryland, New York, or New Jersey, you were operating under a fundamentally different default rule than you were used to in your home state, one where simply walking into an ordinary store with your permitted firearm could itself be a crime, unless you had somehow confirmed in advance that the specific business welcomed firearms. Many longtime permit holders who split time between states have described developing their own informal workarounds over the years, simply choosing not to carry at all while in their winter or summer state specifically because the private property rules felt too uncertain to navigate confidently, effectively giving up a right they exercised without hesitation back home, purely out of caution about an unclear legal landscape in their second state. This ruling begins to close that gap, but only gradually, and only as it actually gets applied to the other states' similar laws. Meaning right now, in the months immediately following this decision, You genuinely cannot assume the practical rules have already caught up everywhere. The legal reasoning eventually will apply. The second segment is what you specifically need to check if you live in or regularly travel to one of the 4 other states this ruling's reasoning directly threatens. California, Maryland, New York, and New Jersey each have their own version of a law requiring some form of affirmative permission before carrying on to private property open to the public. And while legal experts widely expect these laws to face successful challenges using the exact reasoning from Wolford versus Lopez, none of them have actually been struck down yet as of this ruling's release. New York's version emerged as part of a broader legislative package the state passed specifically in response to the Supreme Court's 2022 Bruin decision, sometimes referred to as the Concealed Carry Improvement Act, which bundled the private property permission requirement together with a range of other carry restrictions, covering everything from public transit to sensitive locations. California and New Jersey passed their own versions around the same general period, each responding to the same legal landscape Bruin created, but through their own state legislative processes, meaning the exact wording, exceptions, and enforcement mechanisms differ somewhat from state to state, even though the underlying default to prohibited structure is broadly similar across all of them. This distinction matters enormously in practice. Wolford versus Lopez directly and immediately changed the law in Hawaii. It did not automatically change the law in these other 4 states, even though the legal reasoning underlying it applies with real force to their similar statutes. Until a court actually issues a ruling striking down or enjoining each state's specific version of this law, the old rule, permission required by default, remains technically in effect and enforceable in those states, meaning if you carry in California, Maryland, New York, or New Jersey right now, you should continue operating under the old, more restrictive assumption until you've confirmed your specific state's law has actually been struck down or meaningfully changed, not simply because the Supreme Court's reasoning suggests it eventually will be. The third segment is what to actually do if you're relocating to a new state after retirement, because this is a situation an enormous number of people navigate every year, and one where getting the local rules wrong carries real legal risk. If you're planning a move or have recently moved to any state, checking that state's current concealed carry laws directly, ideally through the state's official Attorney General's office or state police website, rather than through general online searches or forum posts, which can easily be outdated, especially in this specific area of law right now, given how quickly it's shifting. Real estate agents, moving companies, and retirement community staff are generally not reliable sources for this kind of legal detail either, however helpful they might be with the rest of your relocation, simply because gun law specifics fall well outside their area of expertise, and they may unintentionally pass along outdated or locally specific misinformation picked up from other clients over the years. If you're moving to or already living in California, Maryland, New York, or New Jersey specifically, understand that you're in a genuine transition period where the old default to prohibited rule may still be technically enforceable even though it's now under serious legal threat, and checking for updates on litigation specifically challenging your state's law is worth doing regularly, rather than assuming a single check when you first moved is sufficient. The fourth segment is a practical habit worth building regardless of which state you're in or plan to move to, because relying on memorized state-by-state rules alone, especially during a period of active legal change like this one, is a genuinely fragile strategy. Many national concealed carry organizations maintain updated, state-by-state guides specifically covering where you can and cannot carry, including specific coverage of private property rules, and checking these resources periodically, especially before extended travel or a move, is a far more reliable approach than relying on rules you learned years ago that may have since changed, particularly given how much movement this entire area of law has seen since the Supreme Court's 2022 Bruin decision first triggered this whole wave of state legislative responses and subsequent litigation. Consider setting a simple personal routine, checking your destination state's current concealed carry rules a set number of weeks before any extended trip or seasonal relocation, the same way you might check that your medications are refilled or that your travel documents are current, treating it as one more item on a pre-travel checklist rather than something you only think about if a problem arises. If you're the kind of permit holder who has carried responsibly for decades and built up a strong working knowledge of your home state's rules, it's worth being honest with yourself about how much of that knowledge might now be outdated the moment you cross a state line, especially into one of the specific states this ruling's reasoning affects. The fifth segment is what this ruling does not change, because understanding the limits matters just as much as understanding what's new, especially if you're trying to avoid an honest mistake rather than deliberately test a legal boundary. This ruling addresses carrying onto private property open to the public specifically, meaning ordinary businesses. It does not create any new right to carry into someone's private home without their consent. It does not touch the separate category of sensitive places like government buildings, schools, or courthouses that remain restricted under entirely different legal rules, and it does not eliminate a business owner's ability to prohibit firearms on their property. It simply shifts which side has to take the affirmative step. The business now has to post a sign to exclude firearms, rather than you needing permission to carry one in. This last point matters enormously in practice for retirees specifically, because many retirement destinations include a wide range of semi-private community spaces, clubhouses, community centers, medical offices within larger retirement developments that may have their own specific policies worth confirming directly with management rather than assuming a blanket rule applies. Since some of these spaces may not fit neatly into the ordinary open to the public business category this ruling most directly addresses. If you see a posted sign prohibiting firearms at any business in any state, that sign remains fully enforceable regardless of this ruling, and ignoring it carries real legal consequences no different than before. The sixth segment, before we get to the guidance for long-time permit holders, is a related but genuinely separate issue worth clearing up, because retirees managing seasonal travel often conflate two different legal questions that actually require two different kinds of checking. The first question is whether your home state's concealed carry permit is even recognized in the state you're traveling to or through at all, a separate legal concept called reciprocity that has nothing directly to do with the Woolford ruling. The second question, the one Woolford versus Lopez actually addresses, is what happens once you're in a state that does recognize your permit, specifically where within that state you're allowed to actually carry once you're legally present with a recognized permit. These are genuinely separate legal questions, and getting confident about one doesn't tell you anything reliable about the other. A state might fully recognize your out-of-state permit through a reciprocity agreement while still maintaining a restrictive private property default rule like the one Hawaii had, meaning you could be perfectly legal simply carrying in that state generally while still running into trouble the moment you walk into a specific unposted business. Some retirees carry a printed or digital reciprocity map as part of their regular travel preparation, and it's worth treating the private property default rule as a second, equally important layer to check alongside that map, not something you can assume is automatically covered just because reciprocity itself checks out. Checking both questions separately, rather than assuming a positive answer on reciprocity means you're fully covered everywhere in that state, is worth building into your standard travel preparation, especially for extended stays in a seasonal second home or during any relocation. The seventh segment is specific guidance if you're someone managing a firearm collection or carry practice built up over many years, possibly decades, because the legal landscape you learned your original rules under may look meaningfully different today than it did when you first got your permit. If you obtained your concealed carry permit years or decades ago before Bruin reshaped this entire area of constitutional law in 2022, it's worth treating your understanding of where and how you can legally carry as something that needs periodic updating, the same way you'd periodically check on other important legal or financial matters, rather than assuming the rules you learned once remain permanently accurate. This isn't a criticism of your original knowledge. It reflects a genuine, significant shift in how courts have approached Second Amendment questions over just the past several years. One that has moved unusually fast by the normal standards of constitutional law, meaning even experienced, careful permit holders can find themselves working from outdated assumptions without realizing it. The eighth segment is what to expect over the coming months as this ruling's effects continue to unfold, because the current moment is genuinely a transition period rather than a final, settled state of the law. Expect litigation challenging California's, Maryland's, New York's, and New Jersey's similar laws to move forward using Woolford versus Lopez as the controlling precedent, and expect that process to take real time, likely months at minimum, before any of those states' laws are formally struck down or meaningfully modified through court order. In the meantime, expect continued confusion and inconsistency. Some businesses in these states may begin posting welcome signage proactively in anticipation of an eventual change. Others may wait for a final court ruling before adjusting anything, meaning the practical, on-the-ground experience of carrying in these specific states may remain genuinely unclear and inconsistent for a period, even after the underlying legal question has been effectively resolved by the Supreme Court's reasoning in Hawaii's case. Let's step back and name what actually matters most for you personally out of everything covered here. If you carry a firearm and you travel between states, relocate after retirement, or simply want to understand exactly where you stand today, rather than where the law is heading eventually, the single most important habit is checking your specific state's current law directly, rather than relying on general awareness that gun rights have been expanding nationally in recent years. That general awareness is accurate as a broad trend, but it tells you almost nothing useful about whether a specific business in a specific state on a specific day is a place you can legally carry into right now. Hawaii's rule changed immediately and directly on June 25, 2026. The other 4 states' similar rules have not yet changed, even though legal experts widely expect them to eventually follow the same path. And betting your legal safety on an outcome that hasn't happened yet is a genuinely risky approach during exactly this kind of transition period. It's worth acknowledging directly that navigating this kind of shifting legal landscape is genuinely more work than it should be, and that frustration is legitimate regardless of how you feel about the underlying policy questions. You did the work to get properly licensed, you've carried responsibly, possibly for decades, and the idea that the specific rules can shift meaningfully depending on which side of a state line you're standing on, and can keep shifting even after a major Supreme Court ruling depending on how quickly other states' litigation actually resolves, is a genuinely reasonable thing to find frustrating. The practical answer isn't to give up on staying current. It's to build the habit of checking specifically and directly into your normal routine around travel and relocation, the same way you'd check weather conditions or road closures before a long trip, treating it as routine due diligence rather than an occasional afterthought. If you take one thing away from this breakdown, let it be this. A Supreme Court ruling with major nationwide implications for gun owners is significant, but significant does not mean immediately and automatically applicable everywhere the underlying reasoning eventually reaches. If you're retired, traveling, or relocating, and you carry a firearm, treat every new state you enter as its own specific legal environment, worth checking directly for current information, not an assumption carried over from what you've heard about the broader national trend. That habit, boring as it sounds, is worth far more than any single piece of news about a ruling like this one, because it protects you, regardless of how quickly or slowly the rest of the country actually catches up to what the Supreme Court has now made clear in Hawaii's case specifically. If this helped you understand what to actually check before your next trip or move, share it with a fellow permit holder who travels or has relocated recently. Subscribe so you catch the next update on how this ruling's effects spread to other states, and I will see you in the next one.